Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. Today we're going to talk about decision making in the middle of the divorce. Now, you have to understand that decision making is probably done one way before the divorce and one way after the divorce. Before the divorce, it's probably a function of who's running the point on making major decisions in the household. It might be more democratic than that. It might be more of a different kind of a thing where, mom's making major decisions, let's say about doctors' things and stuff like that. Dad may be making the recreational decisions, but that's how it's done in the household. Now, after the divorce, the decision may be made based on what the court ordered. If the court, for example, ordered that the parties are sharing legal custody, then that tells us who's making the decisions. Day-to-day decisions on small stuff will be made by the custodial parent, but the major things regarding health, education, religion, these kinds of things are a function of joint legal custody. Both parties are making those decisions. And if they can't agree, then they have to go before the court. But the question becomes, what about in the interim stage? We're not really married anymore because we're getting divorced, so we're not doing that format. We don't have a judgment of divorce that establishes custody, so we don't have the format that pertains to us after the divorce. What's the picture look like in the middle of the divorce? And the answer is that the parties should, in the absence of court orders, continue to maintain the status quo, and that means they should continue to try to make decisions regarding the children as they have all the way along. Now, if they cannot agree, if, let's say, during the divorce we have a dispute about who's taking the kids where for winter break. The husband wanted to take them to Florida. He has off. He bought tickets. Wife wants to bring the kids to Des Moines to see grandparents. What do? Well, the parties are going to be urged to try and work it out, to try and work out something that makes sense. What's in the best interest of the children? What are they going to enjoy more? What is going to be more important to them? Is the trip to see grandparents? Of course that's important, but is it more important to the parent or more important to the child? Did the child just see grandparents Thanksgiving? Maybe they don't need to spend winter with grandparents, and maybe the trip to Florida might be better for them, might be more fun. They can do some parasailing and some jet skiing. Maybe that will resonate more with them and they'll like that more. Maybe that's the consideration that has to take place. But if the parties cannot agree, if they cannot work it out, then you're going to go before the judge. And the judge is going to make the call as to what we're doing this holiday for the parenting time as it relates to the children. Now, the court may very well say, you know what, it sounds like a good opportunity for the kids to go away to Florida. It'll be nice. They'll get out of the colds. Their friends are also going to be there. This sounds like a nice opportunity. So the kids are going to Florida this year. Next year, Dad, be mindful of the fact that next year they're going to Mom. And the court may work that out. The court may say this is a clear situation where you should go odd years one year, even years the other parent, and do it that way. On, off, on, off. The court may very well do that. The court might determine that if we can't agree that we're going to split the holiday in half. And we're going to, if we got 10 days, 5 days with Mom, 5 days with Dad. That may be what the court does. It may ruin a lot of people's plans though. So you have to understand one thing. The court is overall going to look at the picture and try to be as fair about it as possible. Fairness, as described and understood by the court, might not be what you think is fair. So understand that once you say, we can't agree, judge, you decide, you're putting it in the hands of the guy that wears the black robe, and you may not like what he decides. And even if you like it this year, you may find that next year that plan is no good. So my advice to you is this. It is better to even begrudgingly work something out yourselves and have it be your plan, then go before the judge and have it be his plan. Because while you may think he's 100% going to agree with you, judges are experts in somehow disappointing both parties at the same time. So you have to realize that it may not go 100% the way you plan. As a matter of fact, it hardly ever goes 100% the way somebody plans. So in light of that, it behooves you to try and work it out as best as you can. If not, of course, the court will make the call. If you have any questions about this, reach out and we'll be glad to help you out.